You know, so,
Yep.
Mary, you ready? You need-
I'm all ready.
Okay. I would like to call to order the design review board meeting for Wednesday, Thursday, December 19th. First item on the agenda is the approval of the December 5th, 2024 meeting minutes. The board had a chance to review those. Any motions, questions, or?
I move we approve those excellent minutes.
Second. First and second, all in favor, say aye.
Aye.
Anyone opposed? Motion carries. The next item is item number 3, remand from Board of Appeals of the prior design review board approval of the design for the proposed multifamily redevelopment located at 2418, 2420 and 2428 East Capitol Drive. What do we have here for this? Joe or Nathan, who wants the, want me to take Nathan, or you guys introduce it?
Sure, I'd be happy to. First of all, just want to make sure, can everybody hear me okay?
Yes.
Yes.
Great, okay. I want to thank you for allowing me to appear remotely. After a positive COVID test yesterday, I'm reporting from the portion of the home where my wife and daughter have quarantined me to. So, so thank you for doing that. I guess to summarize, by the way, has everybody had an opportunity to read the December 16th, 2024 memo to the design review board that was with the packet? If so, I'll kind of hit the highlights on that. And I'll give you the sort of the Cliff Notes version of how we got here and what needs to take place this evening. So I guess I would refer to that. I came up with this the other day as my daughter was showing me something on her math homework that it was my daughter who's in high school is showing me something in her math homework, and I'm calling this the show us your work remand. It was a math problem where the answer was accurate, but there were points deducted for not showing the work. So what essentially happened here is in March 24th of 2022, the developer of the project appeared before the design review board for the limited purpose of evaluating the aesthetic elements of the proposed complex. At the conclusion of the meeting, design review board deemed that those design elements were appropriate. They discussed them. They reviewed the materials that were submitted by the developer, and on a vote, they approved the design elements of this particular project that now encompasses 2418, 2420, and 2428 East Capitol Drive, Shorewood. So the neighborhood association then subsequently appealed that decision, appeared in June of 2022 before the Board of Appeals, and said, well, you know, we appeal the approval of the design elements. There was discussion there, and the question was posed, you know, well, what are the design elements that you object to? And there really wasn't anything identified. The argument was that, well, it's too big for the scope of the size, et cetera, et cetera. And those are elements that are covered by the zoning district, such as height, size, and those other issues. Those were not design elements that were reviewed by the Board of Appeals. So on a vote, the Board of Appeals approved the earlier design review board's approval of the design elements, and that was appealed to Circuit Court. So the Circuit Court performed what they call a certiorari review, and the court said, you know, had good things to say about the process, and had said that, and I'm quoting for some of the court's decision. The record here is voluminous, tribute to the skill of the parties involved, and noting that the hearings were lengthy and professionally run. And the court said that the pictures therein show what appears to be an attractive place to live, and that the construction appears first rate. However, there was one area where, this is why I call it the show your work remand. The court said under the previous design review board ordinance under 225.12, it said that they were to evaluate whether the proposed design elements would cause substantial depreciation in the value of the applicant's property or neighboring properties. And the court said, I understand that they approved the design elements, and that, there was an argument that was, of course, that consideration was implicit in what they did, but I don't see that explicitly there. So I'm going to remand it for further evaluation of whether those design elements, or to essentially show your work and further discuss how those design elements do not significantly negatively impact the neighboring properties or the property itself. In other words, in layman's terms, from an architectural standpoint, is the thing so ugly that it would diminish its own value in short order because it's so out of step with common and up-to-date design elements, or would it be essentially so ugly that it would diminish the neighboring property values? So that is essentially what came back to the Board of Appeals, and the Board of Appeals said, hey, the entity that really knows about that stuff, who has the expertise in evaluating design elements, is really the board of the design review board, not us as the Board of Appeals. So we're going to send it further back to them to evaluate. And I want to quote from the Smith versus Brookfield case that the court put in its decision to give guidance on how the remand should go. And it talks about the review. It says before a building permit should issue, the building board must find that the exterior architectural appeal and functional plan of the proposed structure will, when erected, not be so at variance with either the exterior architectural appeal and functional plan of the structures already constructed or in the course of construction in the immediate neighborhood or the character and applicable district as to cause of substantial depreciation in the property values of said neighborhood within the applicable district. So again, this is not a zoning question. This particular body does not get to set, height restrictions or the size of what might be allowed on a particular property. That's all governed by the underlying zoning. So if somebody says, well, 4 stories is too high or 3 stories is too high, that's not something within the realm of the design review board's purview. So the show your work assignment tonight is to reopen the record, review the previously submitted materials, which include all of the documents submitted by the developer when they first came and received approval of the design elements, those designs, those photos, those exterior, well, they weren't photos at the time because it was before it went up, but the exterior renderings, etc., and further discuss, and further lay a foundation for why the design review board previously approved those design elements as being acceptable, and talk about it in relationship to whether or not those design elements would negatively or significantly negatively impact its own value or the value of neighboring properties. There's 2 attorneys on this matter. I'm here to advise on process. Attorney Joe Worth has represented the village's interest in the litigation, and I think that it would be appropriate to hear his take on it, an explanation of it. And Mr. Joe Sincata, Attorney Joe Sincata, is here on behalf of the association, and it would be appropriate for him to weigh in and hear argument from him as to why he believes that the exterior design elements don't meet that standard. And the case law indicates that no new evidence should be evaluated, that it should just be on remand, that the design review board's direction here is to simply evaluate and review the original record and further flesh out the record of why it decided to support these design elements and approve them, and make a more of a record on that specific question related to depreciation. And then after it's done that, move to close the record. It will be further reviewed by the Board of Appeals and passed back up to the Circuit Court for final review as directed by the court. The last thing that the court noted in its decision here is that in finalizing the court's order, it said that in this court's opinion, not much is required. And the court was indicating that, that further record should be developed on the depreciation, substantial depreciation issue, and then the records to be closed, and then it passed back up pursuant to the court's order. So I'll turn it back over to the chair, entertain any questions. Otherwise, I think it would be appropriate to hear from both of the attorneys and then have that discussion and then move to close the record. Thank you.
All right, and I got a couple of questions just real quick before I have the attorneys. And so one is the board has changed hands since then. I mean, this is several years ago. So I think we do have though were you on? Yeah, so there was 4 of us that were on that matter. Does that matter at all for our proceedings?
No.
That we have yeah, okay, great. And then the other one is, the building exists now. So we're just right in front of us. It doesn't look like we have any photos as far as I can tell of that one, but one photo. So I'm presuming we're just reviewing our packet, not photos or anything. Right. Right.
Right. Well, normally the design review board would be making this decision before it went up, right? So to supplement the record with, after the fact things would be, I think, in derogation of a couple of the cases that say, especially the Heartland Sportsman Club versus City of Delafield case that came out in 2020, where it says you don't supplement the record on remand. So I think it's based upon what was submitted by the original, the developer, and what is part of the original record. You go back and as we said earlier, just flesh that out a little bit and discuss that specific element so the court has something to hang its hat on with respect to the substantial depreciation question.
Okay. So with that, is there any more you have to add?
I'm Joe Worth. I'm the lawyer who's handling the case on behalf of the village in the trial court. And I'll try to, I'm here basically to be a traffic cop for what the court said, okay? Nathan will guide you on procedure for how you go, but there is an avenue where courts can remand to an administrative body, and they are allowed to, in certain rare circumstances, ask that administrative body to expand the record, and the quote is, "The public policy of promoting confidence in impartial tribunals may justify expansion of the certiorari record." And so that's on one side. On the other side is some case law that says it can't be a self-serving remand where decision gets challenged by the court and all the tribunal does, all the decision-making body does is add evidence and say, we now rely on that evidence because that wasn't there at the time. So you have to kind of walk that middle line where you're doing what the court said. And what the court in this case said is that I've reviewed all the record. I see everything you've done. The record is voluminous. The record is well done, but I don't see a specific discussion on the issue of whether the design elements of this project substantially depreciate the value of the neighboring projects. And what the court said in its decision is, that's really not for the court to decide. You guys are the boots on the ground design element people. So I am remanding with instructions that you follow my order and expand the record to include a discussion of the element of whether the design elements of this project substantially depreciate either the property itself or the neighboring properties. I have some suggested topics you can discuss on, but this is all your discretion at this point. So it's essentially, the record doesn't contain enough discussion of whether the design of this project substantially depreciate the neighboring properties. Add that to the record and I'll take another look at it.
So depreciate, you want to know if that building has depreciated the value. It's not.
The way the ordinance used to read is whether or not you have to make a finding that the design elements of the project do not substantially depreciate the parcel itself,
Mhm.
which I'll leave that up to you whether developers would build something that depreciates their parcel. But from the court's perspective, what it specifically isolated is depreciate the value of the neighboring properties. And so Mr. Sincata has the old joke that there are lawyers because there are lawyers. Mr. Sincata has a different perspective perhaps on what your assignment is. But my perspective, I've presented to you. I've got some discussion points in case you need help in that respect, but otherwise, you're creating the record that the court will look at on the single issue of whether the design elements depreciate the value of the neighboring properties.
Because I have just one more follow-up to Mary's is so, I mean, we're essentially rolling back the clock as though it would have happened or would do that to the properties, regardless of where property values may be today.
You
This
almost,
is-
yeah, exactly. And I think that what the court is interested in is this is the kind of body that is comprised of people that knew property values and knew
Okay.
what was going on in that era and knew and there's almost a suggestion that what you implicitly might have felt as you reviewed this and made your decision should have been made explicit. So that's what we're doing tonight.
Okay. Does the board have any questions for these guys before we hear the opposing sort of view?
I do have one question. Substantially depreciate is used in a variety of ways and times here.
Yep.
Is there a definition for what that is, like objectively, or is that one of those areas that is
What
stated?
it is substantial depreciation in the ordinances back in 2022 was not specifically defined.
Mhm.
So what courts do when terms are not specifically defined is they resort to the commonplace understanding of the word. Frequently, they cite to dictionaries.
Sure.
So assuming that you would ask that question, the majority of the dictionaries refer to depreciation as permanent decrease in value. So you have an understanding of the word depreciation as a body and as individuals. You have, like I said earlier, the boots on the ground perspective of property values and the design elements and its place in the neighborhood and whether or not substantially depreciated property values resulted. So commonplace understanding of the term.
All right, anybody else? What do we have?
Yeah, can I pull up to the?
Yeah, please.
Thanks. Oh, let's start with,
You need to show anything, let us know too.
yeah,
From our packet.
okay, I don't think you have my stuff, but get to that.
Okay.
So my name is Joe Sincata, I'm an attorney here, I live in Shorewood. I do land use related cases as well as other things. And I represent the neighborhood association that was established when this project first was started, called the East Capitol Neighbors Association, ECNA. Mr. Walsh, Dan Walsh, who lives very near the property and the development, is kind of the lead member of the ECNA Association. So he's here tonight as well. I want to start with, well, first, there's a bit of a broader picture, which is that the project did create frustration in a lot of the neighbors. There were several meetings. There are other disputes that are still ongoing about the project. This was one of them. And this arose because the design review board, it's my understanding, I think it's correct, needs to approve the project and the design in order for the developer to get the building permit ultimately. So that happened back years ago now. And when we looked at it, we believe that the design review board did not act according to what the ordinances required. And specifically, I'll just read the actual language for you. Says in order for the board, that's you guys, to approve an application, shall find and determine that the applicant's proposal is consistent with design criteria and will not contribute to substantial depreciation in the value of the applicant's property or neighboring properties. So that was what we believed needed to happen back a few years back with this body. I think there was 3 meetings actually. And the primary, then we went to the Board of Appeals, which is the proper path. And there was 2 things. The main issue we said is, look, that we think the advice that the design review board got was not correct. That they did need to evaluate this and make this finding about property values. And specifically to find that it would not substantially depreciate the neighboring property. So that was a legal question that we put to the Board of Appeals. And there was a 2-to-1 vote that said, well, we don't agree. We think the design review board did fine. There was 1 dissenting member. The next stop is circuit court. So we went to circuit court and made a similar argument. Judge, I think the ordinances, which are the law of the land for the village, require the design review board to make this finding that there would be no substantial depreciation. And the court agreed with us. It said that this body, the members at the time, and the body as a whole at the time, made an error of law, that they needed to apply the ordinance and make that finding and determination. The court then went on to evaluate the record to see whether the facts in the record, which is what's before you, the existing record, would be sufficient to justify such a finding. So in that respect, what the court decision from the circuit court said, I gather you guys don't have that decision, which is unfortunate, but the court said the DRB had to review the facts and find and determine whether the project and design would not substantially depreciate the neighboring property values. Secondly, the court looked at the existing record to determine if there were facts in the record to otherwise justify that finding. Now, the actual language of you've got a lot of interpretations from the other lawyers, but the court actually said the record is bereft of facts that could support a finding that the project would not substantially depreciate the value of the neighboring properties. The court didn't say it would depreciate, it just said there are no facts in the record sufficient to make that finding, to make a reasonable finding that that's the case. Further on in the court's ruling, the court said the record here, however, gives the court no factual basis upon which to find and determine substantial depreciation to the neighboring properties. So the court remanded, sent the case back, first to the Board of Appeals and then here. And here's where we start to differ maybe even more so. Our view of what this body now is required to do is to some extent put themselves back in time. A bit of a digression. The fact that the building went up really can't be held against us in the challengers because everyone knew we were challenging it. They went ahead and built it anyway. And the court can still order that, this was wrong. So it's not a moot situation. But going back in time to that point when it was a design and it was presentation, what didn't happen at the time was the developer, the applicant, coming forward with information that would address the depreciation of value. And this is what I just read. The court found there is none of that in the record. So when he sent it back, I say when the court sent this back, our view is that in order to cure this problem, this body needs to have a hearing where it allows for additional facts to come in if the applicant wants to provide them. That would support that type of finding. And then it has to make that finding as if it was back years ago. The conundrum, the problem, and the conflict, I think, for this body particularly is that the court has already said, as a matter of law, there aren't sufficient facts in the record to justify a finding that it will not substantially depreciate. In our view, if the applicant doesn't come forward with further facts, present them at this type of proceeding, this body is sort of stuck because the court already said you can't make this finding on the existing record. Now I'll explain where Counsel Worth and Attorney Bear have said something different. They have said you need to have a discussion and show your work. This would get into a problem because what you'd be doing essentially is looking back at things thinking about it, maybe adding your own personal views, and redeciding the question that should have been decided a few years ago. But it would necessarily involve you relying on either new facts you can't put in the record, or as a government, or deciding on the same facts, but again, the same way. Well, the court's already said that's not going to do. So in order for the applicant, and they really should be here in our view, to achieve an approval by this body that makes their building compliant, we believe they had to come forward with some factual information that would supplement the record sufficiently to allow this body to make this finding. And we think you have to make that finding. You can't just have a discussion about it. I'm going to stay on this moment just this a bit because I want to draw a distinction, because we're saying new facts are needed and you're being told and advised that new facts can't be included. The difference is new facts cannot be included in the second round by the government. The idea is if the government makes a decision that's adverse and the circuit court says, no, the developer should get the permit, then the government can't say, okay, we're going to bring in some more bad information and deny it again. The government can't add new facts to the record. But the court, in this case, circuit court, did send this back and did reference testimony, expert testimony and documents as being the not very much that was referred to, i.e. facts. So the court is allowing this body to open the record and take in new facts. That is a difference of opinion on what's required. If the body doesn't take in new facts and just has a discussion sort of internally based on the existing record, and then comes up with the same decision essentially as before, but maybe says some magic words, I believe you're going to be back there again, because I don't think that's going to satisfy the circuit court's ruling. The other issue I want to address is, well, I'll give you a quote, just to put a little more teeth in it. Affording the government decision maker a second kick at the cat on remand violates the standards of due process. The courts have said the government decision maker's grounds must be established in a single proceeding. To permit a second hearing would be analogous to allowing a second trial to shore up the record, support the judgment. To me, I think Judge McAdams, if he keeps this case, is going to look at what's happening here as exactly that. Basically, you're being told shore up the record, and that'll help us get this pass go with the court. I think that's going to lead you to another due process violation. The second primary thing that I want to mention is this is not a review that's limited to what's been termed design elements. Many of you, I think that one might be in your bailiwick mostly, but the ordinance specifically says the standard is based on the design criteria. And design criteria is defined in the ordinance as including the scale of the building. I can read that to you, if I may, just so you have that. So yeah, the design, this is under section 225.12H. By the way, these ordinances are the ones that were in place at the time. And I think that we're reading you the stuff that was in place at the time.
Just to interject, they have changed. So if you're familiar with the current ones, these are it.
Some have changed. I think we all agree, though, you do need to apply the ones that were effective. In making its findings and determination, the board, concerning each proposed project, the design review board shall give substantial weight to the intent of the village that the decisions of the design review board perpetuate and further the character of Shorewood, including without any limitation, the following: a human scale in the village as a whole, including its architecture and land use, with an accompanying recognition that the village is characterized by a substantial amount of pedestrian and bike traffic, high quality design and construction, consistency in design of commercial properties with primarily residential nature of the village, diversity of architecture. So I listed these in my stuff. I don't think you have it, but that's the ordinance. So this goes to this narrowing that the attorneys are suggesting you should apply, which is to only focus on fenestration or cladding or the colors. That's not sufficient in our view. And I think that will lead to another up and down here with the courts to say, Judge, the advice they got was incorrect because it limited their scope. It limited the scope of what they can consider. And what I mean by that is that you can consider, well, I'll say it. So Attorney Bear in his analysis that factors such as height, overall size, and other construction parameters governed by the zoning district, or the zoning of the district, are not design elements to be evaluated by the DRB. This finds no support in the case law, no support anywhere in the ordinances. It's exactly contrary to the ordinances. Attorney Bear cited the Smith case. He was reading the Smith case. The Smith case was citing itself a separate ordinance from the city of Brookfield. The case was not saying that these kinds of bodies are limited to only design elements. I would also note that I think as professionals in the design field, that I think it's pretty well understood in the industry that the size, massing, location of a building on a property has a significant impact on that building and the others. And it's certainly considered when you are proposing a design. So it's something that is very much part of the design process. And we think it's important, at least from our perspective, that the size and height and massing and those issues do need to be considered in making this determination. The determination, again, is whether it will contribute to the substantial depreciation of the neighboring properties. I would say too, and this gets a little more of a policy-based argument, but part of why we're here is that we feel the process kind of broke down, and we have neighbors now and they're living there and they objected and they think the law is not being followed. And part of that is that this body is not doing as broad of a job in review of this as it should. And that's driven particularly not by trying to stop everything. The folks wanted, and they made it clear, they wanted a project that fit the ordinances and that was an appropriate scale in their view, and they feel the ordinances required that. But this body, I think, also needs to reflect on who its client is, if you will. And I think that the body is set up to be independent of the politics. And its client, to me, is really the neighborhood, the community broadly, not the developer and not really even the staff. It's supposed to be a check on that, in our view. I think that's why these boards were set up. The Historical Preservation Commission is analogous. And they're trying to protect properties and communities for the long term. When that breaks down, that's when you get this type of litigation. But if the bodies within the village are acting and having in their perspective, we have to think of the broader community. I think these things can be avoided. That's relevant because when you're doing that, that's your mindset on how you should apply this rule. Then considering the size, the shadow effects, the loss of light, the massing, the scale, of course you would consider that in making this determination. So we think there are very strong reasons why the limitation you can put on you, what you can consider, is not accurate and not required, and I think will lead to further dispute as we proceed. Those are my two main things. I did want to note that in our submission, we had, in preparation for this, obtained an affidavit from a gentleman named Dan Mickelson. And I did provide that to council. And I'm going to read it, and I'm going to put this in the record. These are additional factual materials in the form of expert opinion. You've been told that you can't consider these. So before I read it, I want to know if the other lawyers want to prohibit me from reading it, or if they are going to allow me to read it as kind of an offer of proof. And before I let them speak, the reason I need to worry about this is if I don't put this in the record and we go up and we have further litigation and we argue, and then one of the lawyers says, well, you don't have any facts on your side. Well, I was told I couldn't put them in. Well, you should have put them in. So I can't even. So when you have to worry that a judge is going to say, look, there's nothing here for me to decide because you didn't come with any facts. We are coming with facts, even though we don't have to. The applicant has to show it will not substantially depreciate. However, we believe, consistent with the whole mission of this group, we wanted to provide facts to show that we believe it will, if we're back 3 years ago, and it is. So with that said, I'm going to read a couple of excerpts, if that's all right, from this expert affidavit.
Here's what I'll say about that. I've got comments on each of those points, so I will speak again one more time before you guys.
Well, I have a couple more things, but this is one of my things, and I'm going to wrap up.
One of my advices or one of my positions with respect to the litigation, what the judge ordered, will address whether or not you should consider new evidence. I don't see any reason that it can't be, in trials, we mark exhibits, offer exhibits, and the court receives exhibits. So there's no reason we can't mark and offer this, and then the court can decide later whether it should have been received. Or you can decide as the tribunal, after I tell you what I believe the court order says, whether you can receive it. So in the three elements of evidence, mark, offer, and receive, I don't have an objection to him marking and offering what he's about to mark and offer for you. Whether you receive it for the purposes of the court assignment, we can, you can decide, and I can give you my perspective on that.
Well, let me just say, that is reasonable. It's already been offered. It's in the pack. I've submitted to everybody. I don't think it's in your packet. I guess you guys can have a side discussion. Do you want to hear what I have to say, or do you feel you have to limit?
I'd like to weigh in on that point as well, because I think all these issues sort of dovetail together. There was no such evidence previously offered, and the time to offer that would have been when this was first before the DRB. And this sort of dovetails into the fact that Mr. Sincata has continuously made the argument that the design review board's scope of jurisdiction is much greater than it actually is. Here's the problem with his version of or version of what
presentation.
I know I want to address this because you asked if any of the other attorneys had any issues on it.
Well, on that particular point,
So
we're going to argue the whole case now, Dave.
No, this is ridiculous. We've been here before. Here's the problem with that. If you accept Mr. Sincata's argument, then there is no such thing as zoning other than whatever a design review board in any community says on any given day. And I'll tell you something else. If there was a submission, whenever there is in this state, a submission by a developer that meets the underlying zoning criteria, it comports with the zoning. If the municipality doesn't grant the permit, they're going to get sued and they're going to lose because courts have recognized that there's a property interest in that permit application that meets the zoning code. So that the design review board is not here to evaluate if the code says four stories or 3 stories or 5 stories or 7 stories is allowed. It is not the design review board to say, yeah, but even though the zoning code allows that, we think it's too high or too whatever. We think three would be better. That's not the role of the design review board. The role of design review board is within what the parameters of the zoning code allows. What are the design elements that are proposed? Does it look like a bomb shelter with no windows? Does it use poor siding materials that are going to fall off within a year? Are they visually offensive? This is largely an aesthetic evaluation, and that's the area where the court has said, when I look at the record, I don't see something specifically developed or discussed with respect to substantial depreciation as it relates to those design elements. The design review board does not get to set the zoning code as to whatever they deem is appropriate at any given time. This is much narrower than Mr. Sincata is suggesting. So he can submit whatever he wants, but my advice to you is not to rely upon it and not accept it. There was no such argument that's ever been advanced other than we don't like it, it's too big. Even though it meets the zoning code, we still don't like that many stories or that size. That's not what the design review board, that's not within the design review board's purview. It's trying to make this more complicated than it has to be. So you can put whatever you want, you can make whatever you want, argument you want. My advice to the design review board is to not consider that because A, I've reviewed it. It again improperly addresses the scope in relation to what the zoning parameters are. And B, it was never offered the first time around. And now you're trying to get a second kick at the cat to offer evidence and make arguments that were never made the first time around. So you can argue whatever you want. You can finish your presentation, but my advice to the design review board is to ignore that.
So this gets to a strong difference in opinion on things. On the idea that you just said, you want to offer new evidence and new argument. No. So the evidence that I'm offering is what the court, we believe, suggested what we should be doing. Evidence about the impact on the neighboring properties. I will read a couple excerpts of this, but I have to now address the legal argument that's being made. That the design review board in the village of Shorewood, or really anywhere, I guess, is limited in what it can consider. That is not anywhere supported in any law. It wasn't cited. The circuit court didn't even address it. I wish that Attorney Bear would let you read the circuit court opinion. It's long, but it doesn't address that issue. It doesn't limit your purview at all. And it doesn't make any sense, because if the zoning in a district were to allow 40 stories high, but the property upon which the 40-story building was going to be put up created a stark monolithic wall to the adjacent property, which was a residence, this body, these types of bodies, can say this design does not comport with the community standards. Just because it meets the zoning doesn't mean it's not going to impact property values negatively. So what Attorney Bear is arguing with no support, except his strong statements, is that you can't consider these obvious features of a project if the zoning otherwise allows them. Said otherwise, a developer, a property owner can build to the maximum and there's no way you can do anything about it. Said further, the idea that we're going to litigate a takings case and claim that we're going to lose in an effort to kind of intimidate this body as if, oh, geez, wrong. And the developer should be here to make that argument. So all those things I just disagree with. It doesn't make any sense in the industry or for the purpose of what the design review board is for. And the court, in our view, is opening up the record to allow for evidence. I would not be doing my duty if I didn't come with evidence that shows the other side of that equation, the other side of that balance. What should be happening, and I don't know why the attorneys did not invite the applicant to come. I don't know if they're protecting them or what. They should be providing evidence that allows you to make this determination. Our evidence would say the following from Mr. Mickelson. And the full affidavit is in the record, which provides his bona fides and his experience. He lives here in Shorewood. I can say without reservation that all other things being equal in the village of Shorewood, the development of a single-purpose, high-density, multifamily apartment building of 3 or more stories, where the first floor is used for resident parking, will have a substantial negative effect on single and 2-family property values in the surrounding area. The negative effect will be in proportion to the size of the building, more pronounced the closer the single and 2-family properties are to the building. In fully developed urban communities like Shorewood, this effect can be mitigated or even reversed by following high-quality urban design guidelines. Later in his affidavit, he references the following. The Cornerstone and Ravinia mixed-use apartment building stimulated the commercial revitalization of the north end of Oakland Avenue. And in my opinion, these buildings anchor the most attractive commercial area in the village. The redevelopment efforts at this intersection are a primary driver of a typical homebuyer's notable preference for Shorewood's northeast quadrant, east of Oakland to the lake and north of Capitol to the village limits, where they can live within easy walking distance of both Lake Michigan and commercial offerings on North Oakland. The new building at Stoll Avenue and Capitol employed none of the above strategies, and the results speak for themselves. This is his opinion. The project substantially diminished the value of the homes and duplexes in the neighborhood, especially those in close proximity. But more importantly, and this is important because this is part of our group's concern, it spoiled the opportunity to grow a vibrant retail commercial district on East Capitol Drive. By the way, Mr. Mickelson lives at 4454 North Maryland, licensed real estate broker in 2005, Seal Gallagher. He's been in the industry for a long time. He does this all the time. His credibility is listed in the affidavit. I hope you I can review that before you decide. So I need to, as the attorney, put in evidence that shows our claim is valid. This building, as it was approved, primarily because of the size and the number of stories, the footprint, is substantially depreciating property values of the neighboring properties. The issue is, that is your role to determine that, and the attorneys are telling you you can't consider the obvious features of the building in doing so. I just don't think that's correct. I believe the body should take a breath, read what I've submitted, adjourn this matter, make an independent evaluation of what you believe is required, take the time you need to do it, come back and then decide. As part of that, my suggestion is that you advise, request, encourage staff to say it would be in their interest if the applicant came and provided variance. We'd like to hear that. So those are my thoughts, and I would love to answer some questions if that's okay.
Or to our attorneys. What he has presented is to be assumed as fact, or is this just an opinion?
It's just an opinion.
Well,
Thank you.
as is theirs, as is theirs. So this
Well,
is,
you're questioning us too.
it's an issue. Who are you going to believe? And this is always a challenge because you have an attorney and you're going to, tend to defer to him. I am saying, I think the advice you're getting is inaccurate. I think I have a little base to say that because we won in the first round and the advice was the same, almost the same exact advice.
Bring
you
on the
gave.
issue of
So-
what the
So,
DRB's purview is.
well, no, we're basically asking about credibility. Do we have to
Don't tell me.
believe attorneys? Don't tell him that. That's your entire strategy. Believe us,
No.
don't believe him.
You just told them that you won on the issue of their scope of their purview.
No,
And
I didn't. I said we won on the issue of whether or not the scope of their purview. You
No,
have
whether
to
or
make
not
this.
the record
No, no.
mentions.
No,
Oh,
no,
I'll
no, you read-
I'll read to you what it says when he's. when he's
The
completed his
court,
presentation.
the court said that you didn't follow the law. You didn't employ your duty. Your charge was to make this finding, and you didn't. I'm not across with you guys, but to say that I'm misstating what the issue was and what the court ruled is just totally wrong. The court reversed the ruling. They found against the
No,
village.
it didn't.
You're
It
hiding
remanded
that
with
from-
instructions.
You're hiding that from these people.
I'll read it to you in just a second.
Well, I'm going to read it before I get off the floor here.
Okay. I'll tell you. what-
Here's what the court said. The board not only did not find and determine, but one member rejected that board.
That's
had
the
found-
Board of Appeals.
What happened? You mind, Joe?
That's the Board
That's
of
the
Appeals.
circuit court describing what happened. What happened here, the judge is saying, is clearly contrary to the intent, history, or purpose of the plain meaning of the ordinance. There was no finding and determination. That means you didn't exercise your full scope and purview. To say that I misspoke, Joe, is incorrect. To start to make this about me is unfortunate, and I think that's what you're trying to imply to me. What I suggested is everybody take a pause, look at what I submitted. I would like it if you give it to them. And then they can make their own evaluation. To try to push this through, only design elements, you did nothing wrong before, show your work. We feel those things are incorrect and they're going to lead to further litigation. And I think further activity in the future on this case. So our solution is that you take some time and really think about how to do this and don't feel as if you have to decide tonight.
Question. There's this distinction being drawn between aesthetic design elements and the broader scale. And I'm curious if we're to be talking, or when we looked at it last time, if we're bringing that up, because it's being mentioned as sort of an extended scope or as part of our scope. And I'm
I'll
just
tell you
curious.
two things. First, the court never reached the issue. So to suggest that the opinion doesn't address it is incorrect. I'll read to you what your orders are, what your assignment is. The court finds that the record is currently inadequate to determine if the BOA properly considered whether the proposed housing would cause substantial depreciation to the neighboring properties. 2, additionally, the court cannot determine from its own review of the record here that there was sufficient information for the approval as to substantial depreciation. For those 2 reasons, the court, pursuant to the applicable statute, reverses and remands the matter back to the BOA for further proceedings, consistent with the opinion as to substantial depreciation. You have a 1-line item assignment.
Joe, let me just comment. Joe, none of that deals with the nature of your review. None of that says you're limited to design elements. None of it. That's not in the court's decision. It would be incorrect to say the court limited you to only considering the design elements. It didn't address it because it wasn't an issue.
Actually,
issue is what is the ordinance
I want to
require?
weigh in on that. The court included a large block quote from the Smith versus Brookfield case, talking as an example, talking about the review of exterior architectural appeal and talking about how that exterior architectural appeal wouldn't be so out of variance with either the exterior architectural appeal of the structures nearby or the structure itself as to cause substantial depreciation. So the court cited that for a purpose, and I think was implicitly saying that's it. That's the scope of the review. Because the problem is there's ample case law. There's tons of case law that says once a developer submits a building permit that meets the underlying conditions of the zoning, that they have a property interest that, and if you tell them no, you've got problems. And so the DRB's review is not, well, what do we like? And do we think, even though the zoning code says X amount of stories is fine, we're actually going to restrict them to less than that? No, you can't do that. And the mandate here is simple and clear. It's to do what the design review board has done for years under the old ordinance, which was to have the developer come in and submit the record, which they did, which concludes the drawings, the plans, the specifications that lays out the exterior, the functionality of it and how it's going to look, what the siding is going to be, what the roof is going to be, all those things. And you look at it and you say, is that, is it so visually, is the exterior architectural appeal so visually poor that it's going to depreciate, the neighboring properties? Then you tell them change the design elements. That's not good enough. And that's within your purview. You can do that, but you can't change the underlying zoning. That's not how it works. And if you try to do that, that's where the municipality runs into problems.
You're not changing the zoning. Let me just comment that you're not.
Look, the other analogy I'll make there is if you buy a house next to an area on the block over that's zoned for commercial, but it happens to be an empty lot, and then 10 years later after you buy your house, you can't say, well, now I don't want them to build a commercial construction over there because I don't like it. That's not how it works. And I guarantee when everybody in that area bought their house, the existing zoning already allowed what eventually got built. That is not what we're here about. We're here to evaluate.
Things up.
It did not.
I appreciate you guys having different.
It doesn't matter. The point is,
It's so sad.
Just making things up.
Yeah.
Okay.
I
I
guess
guess,
you have a final.
well, I
comment,
do.
Ted?
I guess on this point that the circuit court somehow is telling you can only consider design elements. Two things. Before you make a decision, I would like you to read the court's ruling. And I think it's problematic. I think that your staff and your lawyers have not provided that to you. It's really a
You
road.
submitted it at 9 o'clock. You submitted it 30 hours. ago.
Gentlemen.
No, guys.
Just let him finish.
What I'm saying is,
30 hours ago.
yeah, that's my stuff. This is the thing. This is what happened, and they are keeping it from you. They could have sent it to you a long time ago. I had to send
You
it.
can't do that. It has to be part of the notice.
To send the court decision to the decision-making body has to be part of a notice.
Court decision was sent to the building.
I'm
Of course it
asking,
was.
I'm asking that you take a look at the court decision and question why it wasn't provided you by your own lawyers. I provided it. I tried to. My stuff has not been given to you as far as I understand. And then look at that and look at this, the quote from this Smith case. The circuit court cited this Smith case to justify the idea of design review boards generally, and the fact that they can make decisions that are different from the zoning that exists in that district. This was a big issue in a case called Saveland in the 1950s. I cited it to the court. The court here approved of it, and within that cited this Smith case.
Wait, the court here approved of what?
Saveland. It
What
said
do you
that
mean it approved of it.
it said it's good law, and it means the DRB can function as it does. And when it makes decisions that impact property values, it's not a takings.
You're talking about McAdams.
Yeah. And so then he cites, so then the Smith decision that's cited is given to you, it's misrepresenting what it is. That decision dealt with a separate ordinance. Quoting the ordinance, what you're being told is because Judge McAdams quoted a case, and within that case, there is some discussion about these things, that therefore implicitly, Judge McAdams is limiting your scope. I don't think that's even close to true. And even the quote itself says architectural appeal and functional plan of the proposed structure. So that's consistent with what we're asking. It makes no sense to look at a building as if it's in a cube and you can't look at anything around it and then try to make a determination about how it's going to affect the neighboring properties. And when someone comes with a building and they're adjacent to a residence, which is the opposite of happened here, the residents were there first, and they needed special permission to build this big building, to say that somehow the neighbors should just be quiet and they're stuck because they live near a commercial property, that's awful. It's not the whole process was corrupted here. And this is one piece of it. This was a new project. It got special permission to be extra big. That's why we're here. So those are important issues. I wish you would read the court decision before you decide. Thank you very much.
I will follow up respectfully here. You have a
Could you
single.
go quickly? We
Yeah.
have to move on.
Okay, you have a single assignment, you understand what it is. The advice you may be getting from the village attorney with respect to your purview is outside my advice in this case. My advice in this case is designed to help you comply with the court's order. So if you have questions with respect to that, if you have concerns with respect to that, feel free to ask me. Otherwise, I think you understand what your assignment is.
Thank you. Nina, would you have a question?
I think I do. My recollection is that we did consider a lot of these things. Is it just a matter of rediscussing them and having them in record?
Well, that's the very crux of what they
Yeah.
are arguing.
Like
So
the
they,
notes were-
this side thinks that that is matter of fact, and this side thinks that is not. So it's really your purview.
The problem from the records perspective is that DRB meetings are generally not recorded.
Right.
So what we have are the minutes become the official
The
record.
new minutes that we approved at the beginning.
And so between the minutes and the recording of the BOA, the court determined that the record did not adequately reflect your consideration of this issue.
Because I think the four of us that were in those meetings, beyond materials, I believe that we talked about massing, we talked about adjacencies, we talked
Sure.
about pedestrian accessibility, traffic issues that are beyond the scope of our, but to me, this was very heavily discussed with a lot of variables.
Okay.
And we're recording tonight, so.
I'm happy to again.
Yeah, sure. You have something?
Yeah, for us that weren't at that meeting and hadn't been on board yet, I mean, do we get to review the minutes of that meeting, or would that be introducing new information?
No, they could review the minutes of those meetings, correct? If they
The,
found that helpful?
the minute, what you could review is the minutes of the, what the record, on March 24th, 2022, what the record contained.
Yeah.
Yeah.
That's what, yeah. Would that be helpful to you?
Oh, yeah.
Okay. Do we need to consider that? Do we need to consider if the rest of the board needs more minutes?
I mean, I don't know where, I mean, I don't know where that will take you, only because the court has said that because there was no, there was no recording of the earlier one, the court didn't have the opportunity to review the extent to which the Board of Appeal or the Design Review Board had discussed that matter. And then that, so by definition, it couldn't be reflected in the Board of Appeals evaluation of it. And they were just going on the minutes. So we're recording it tonight, and the court would like to see a discussion of those elements. Or, if you're saying if you were there the first time around and we discussed X, A, B, C, and D, to reflect that and share that with the other members that are here tonight and discuss that. And I think, the process is, again, to do this the same way that every other design review board has conducted a review of a prospective project under the old system, where the substantial depreciation was a listed factor under the ordinance, even though it no longer is to look at what exactly was submitted. And again, I don't know, obviously the developer knew that the meeting was going to take place, and I'm presuming the reason they didn't come is because they weren't going to submit anything new in the record and felt that whatever you had from the original submission, which is what you would normally have under any other evaluation, was adequate. So look at what was originally submitted, look at the design elements therein, and then flesh out the record on the substantial depreciation question.
I just make a quick response. I think that the minutes, of course, are certainly something you guys can review. That's in the record.
Sure.
But to also to say, well, don't look at the minutes. I know what the purpose of that is.
No, I don't mind if you look at the minutes.
Okay.
I just don't know where it'll get you. I mean,
Well, I mean, that's for them to decide, it seems to me. So we agree with that idea, but also we don't agree that it should be members that were there at the time should be recreating what happened then for the new members and sort of redoing the hearing back then. That to me is going to get you in trouble from our perspective. I think because the court limited itself to the minutes, I think this body is limited to the minutes. And therefore, you can't go back and say, well, we talked about all this then. That would be basically a do-over. And I don't think the court allows that. That's my view. But I would definitely look at the minutes.
Thank you.
I don't have any problem. Mr. Worth, any issue with that?
No, I don't think that, a review of the minutes is inappropriate. I think the court has asked that this body address the substantial depreciation issue. I don't believe that people who addressed it the first time around are precluded from giving their conclusion with respect to what they're reviewing. Again, that's not a do-over. That's their assessment. If their assessment has changed, they'll give their changed assessment. But I don't believe that the four members are muzzled from saying again or giving their analysis of it just because they did it once before.
Yeah, come on. Briefly,
Please.
I understand that.
I'd like to wrap this up.
Yeah.
We can end this here.
I think practically that does make some sense, but here's where you run into the problem. The government, as the body that is, you guys are the government tonight, is not supposed to kind of have another chance to just do over based on what they did before. So there is some law, I don't know if Mr. Worth will agree with me, but the law that we've cited, this Heartland Sportsman's case, it's concerned about this type of thing where we have a remand from the court and the court says you didn't do the right job. And then the body says, okay, let's rediscuss it and then bring in some more facts and we can make that same decision and it'll be well supported. The court says that's not appropriate because it's a violation of due process. So I think reflecting back now and bringing in the stuff that wasn't in the minutes and then talking about it again and making the same decision, that would, I think, run contrary to that ruling. But, you know, people can disagree. That's my view on that.
I don't think you can, I mean, I think if that's their genuine analysis, they're allowed to present the genuine analysis. If it's the same as it was 2 years ago, 3 years ago, it's the same as it was 2 or 3 years ago. So.
And I appreciate your thoughts on that, but to me, this is the exact opposite of a do-over or a new evidence or considering something that wasn't in the record before. It's just somebody that was there saying, hey, part of what the court said was, I can't tell because there's literally no transcript or video of the earlier DRB. So go ahead and discuss it again. And if somebody that was there before said, this is what I remember us discussing at the time, and here's what we considered, I don't see that being inappropriate or inconsistent with the Heartland case, but you know, the body can proceed as it deems appropriate.
All right. Thank you. I think with that, I guess, as a normal course of procedure, we should really review this. I guess I'll entertain any motions if anybody had any for particular things, but I think, you know, in my personal opinion as the chair, that the minutes, you know, that were written down were of the opinion of the members at the time, which is basically what you would be. So if we're going to discuss this like we would discuss a normal process, certainly you could ask questions and things like that. Unfortunately, we don't have the original applicant here to answer those questions. But that being said, I think we've all went through a number of these. We may know the answers from attending those meetings. And so they might have been the right answers, but we might, you know, depend what you're asking. So I would say we would take a look at it and consider it mostly for the topic that we're at hand. But if there's anything else that may be something that we need to speak about, I think we should bring that in.
Yeah, so I'm happy to start.
Go ahead.
I'm, just to make it straight, a master's in architecture and I have an urban planning minor and I've been in design for 20 years. I think this is a scale that is appropriate for the village. I think it's appropriate for Capitol Drive. It is a large corridor. I think materialistically, it is, there's substantial materials, there's brick. I think they're a great choice of materials. So from a massing standpoint, I don't think it is overly large. And I think architecturally, there are things that are being done to this to reduce the scale of it. It's lighter, primarily on that fourth floor. So I think it reduces the scale and the mass of it. It's doing things specifically on the corner. It's putting the entrance on the corner. It's putting the parking into the back of the alleyway. So it's doing things to address the urban scale and the human scale. I think it has good fenestration. And I know as remember in the previous couple meetings before the final one, we had suggested changes to get it into a more pedestrian scale. And I think those changes were addressed.
Do you recall what those changes were from your recollection?
Yeah, we talked about adding the parapet at the top to help cap the top of it. We talked about moving the corner or moving the entrance to the corner. It was in the center. That was the first one. We talked about moving the garage off of Stoll or is it Stoll? And onto the alleyway, which that was accommodated.
We moved some doors into that for the trash and for the egress out from the first floor parking.
So, again, I would say that this, looking at this building, there would be nothing on this building that says it would depreciate any value of anyone around it. And my expert opinion would be that it should increase value of properties because it's mid-rise, low-rise apartment building. It's bringing density to the neighborhood. And we are in urban, suburban village. It's continuing the mass down from Capitol to the west. I think it continues that. It's not substantially bigger than any of those buildings. So I think it would, to me, it was carried out in a manner that would approve.
Yeah, and I think just to add to that, I think adjacency wise, I think it's consistent with the heights of the adjacent buildings. If you take a step back at the elevation of that block and adjacent blocks.
Certainly towards the west, not necessarily.
That was my question. Can we get a picture of them? I guess we can't really get that, but yeah, isn't there isn't it greater than 4 stories, right? One block west?
It's what's that Art Deco building? Yeah,
I think it
looks
Oh,
bigger.
yeah, that
it
one.
has a
Yes.
different.
Which was that just 4 stories too?
It's like-
There's one on the north side and there's
Yeah.
one on the
It's,
south side.
it's much taller.
The Casanova is 6 stories tall, but it is a solid 60 feet from the street.
So you're saying it's not right against the street edge, it's got.
Yeah, 60 feet from the street edge.
And I think
From
prefer it
street
closer
edge.
to the street. I think bringing density to the street edge is better.
He's saying that this particular building.
The FAR
very
is a
close to
lot
the
higher than
sidewalk.
this.
Those are the one right, one block away.
Well, maybe we're talking about different ones. I think we're talking one on the south side.
South side of the street.
The south side.
And one on the north
It's
side.
right up against.
One on the north.
4
side?
stories. That's Shorewood Manor, it's 4 stories.
Yeah, that's 4 stories, so that's a similar size.
Right, because there's this
There's a parking
building,
lot in between.
there's a parking lot for that
Yeah, yeah.
building.
Correct, yeah.
You know, so this would actually better.
Suggest that we go one at a time.
Yeah.
Sure.
So then right, one block over, we got another large apartment building, so this really fits into the neighborhood.
From your opinion.
Yeah, in my opinion. Yeah, fits
I have an
in.
opinion also. I'm a real estate broker and I reside here in Shorewood. And I've been in real estate for 21 years plus maybe. And I've been in this area for 14 years. And we did have discussions in here talking about the valuations that, in my opinion, I feel that it extends activity to the east side of Capitol, helps the businesses that are there, and it helps the neighborhoods. The valuation will be no different for a single family home, in my opinion, than it was when they bought a block north of Capitol. You know, any significant difference than 3 blocks north is just like if I'm someplace west and I move 3 blocks east towards the lake, for the exact same house, you have a different valuation. So you go 3 or 4 blocks north on Stoll, that house is going to have a different valuation than being next door to Capitol. So that was a discussion that we all had here. And I don't know why it didn't make it in, but that was considered. And so that's my opinion.
And you should express whatever opinion that is with, to the issue of substantial depreciation of neighboring property.
So I would say, and I would agree that this building has added to sustaining and elevating the valuations in the neighborhood. And the property itself on those 2 pieces of property have greatly increased the value.
You know, I just thinking back a little bit towards the process that we had previously, you know, we had several bits of neighborhood, you know, comment and participation in that regard. If we are reopening this case, I don't know that we had that opportunity here. Would the board consider other neighbors' opinions or anything, or would they like to hear anybody is there anybody in here that may like to speak about that? There's not, okay, so.
I would be happy to speak about it, just as a neighbor,
So would the board care to hear neighboring opinions in regards to this submission? Sure. Any motions to allow that?
Make a motion that we hear the neighborhoods perspective.
You don't want to hear it? For a second?
You have to
Don't know that we're gonna hear anything.
I'll make it very, very brief.
You have to let them vote.
Yeah, okay.
Currently, we don't have a second, so.
Okay.
We'll move on, so. My opinions sort of echo a little bit about what we've been talking about in regards to, you know, human scale and size. I feel like, you know, the low canopies, the entrances that we talked about, some of the revisions that were done with the balconies, I believe in our first case, I think address some of the scale and size that we were concerned about as a board. I think some of the materiality in this project was of higher quality and would, in my opinion, you know, sort of dovetail into what some of the materials of both the residential and the commercial buildings have in this area. Further west, there is the 4-story building, and so I felt, in my opinion at that time, that that closely related to that. And I think we even had a discussion regarding heights of the church being considerably even higher, but that's further away. So in my opinion, didn't take that too much into effect. As far as the street facade of it and the close nature to the sidewalk, I feel that's what is intended for the zoning. And, you know, from my opinion, as both, you know, a developer and architect that I've done before, I'd obviously do that again. And, you know, most developments that I've done in that regard generally appreciate and increase value of areas that I've worked in. So I, at the time, certainly would have assumed that this would have substantially increased the value of many of the homes in the areas and around, both just because of its adjacency and because of its potential for sort of a landmark in the area. We're like, oh, are you by the Atwater? And no, I'm right behind it. I'm over near it. And so in my opinion, it creates kind of a landmarking area that may be something that people would find notable and noteworthy to keep. So those are my opinions.
And how do they affect your conclusion or your analysis of substantial depreciation?
I thought I just said that, but I don't believe that it would substantially affect depreciation of itself or adjacent properties. Any other guys that didn't have the opportunity to look at this the first time have any questions about the submittals at all?
We're only seeing the last version, I guess, so I don't have, I mean, I followed the
But you can
project.
certainly
when it
comment
was-
on what
Yeah.
you've had before you if you have any comments.
I think it's, you know, it's always difficult with like a larger commercial buildings because it's a series of concessions in between the cost to develop it, build it, and the way that it looks. And I don't mind, you know, as far as I think they've gone to extents to try to make the facade of the building better in a variety of ways. And I did follow the project while it was happening because I also obviously live in the area and I'm interested in it. More on the build side at that time, but you know, I mean, no building is ever perfect, but I think that, like I said, I like a lot of the ways that they've made the top lighter to make reduce. I mean, I think when we were talking about scale and I guess when in the village code or our kind of governing document, when they say that we look at scale, my understanding is that we look at scale of the building itself to itself, not to necessarily every other building that is nearby. And I like the way that they have done the scale out of this building because I think it reduces like we do for any other house, you know, or something too. We don't like to see a giant mass of one type of siding all the way up, you know, all the way across. And we ask people to add windows to it or to do other things to break it up. And I feel like they've done that in this project. They've broken it up, they've changed materials, they've added details. The facade isn't just unilaterally across the entire building. So yeah, you know, I mean,
I guess the only thing I might interject there is that, you know, you are familiar with our code and what we're supposed to do as a design review board. And I
yeah,
don't think it precludes us from looking at neighboring buildings or anything.
no, but when it says like, I think.
Well, you know what it is, but
Yeah.
I guess where I'm going with it is that I do consider neighboring buildings,
Sure,
not just the building itself. So I try to take the context into, you know, sort of heavy weight when I talk about it. I don't want,
yeah,
you know, something that's completely out of character. I mean, a different project that I might cite is when someone was trying to add a spiral staircase on the front of their building, which no other spiral staircase
Sure.
existed in the front of a building. And so that would be out of character, and I based that on other buildings.
yeah, I guess I'm more, you know, because there was some disagreement, I guess, between other people who are involved as to the board's ability to dictate scope and scale of a building.
Sure.
And I understand that to be the scale and scope of the building to itself. As you can't have a one-story house with a two-story parapet in the middle of it that goes really high because it doesn't make sense to itself, right?
Yeah. No, I think it's completely up to your interpretation of what
Yeah.
that means based on knowing what your purview is.
And I don't think this building is out of characteristic with what has been moving north down Oakland and east down Capitol for a number of years. And I don't think it's, I mean, that's kind of the way I feel about it, I guess. I think it certainly doesn't depreciate the value of that property. And I struggle with the description of substantial depreciation of neighboring properties because those types of things aren't just tied to the building that is next door. It's tied to many other things. So it's, I can't really comment on that, I guess, too much. But I think that the building adds density and it allows for greater growth of commercial properties down East Capitol, which is good for the housing that's there. And in that regard, you know, it's hypothetical, but I don't see substantial depreciation. Yes.
Yeah. Okay.
I think one of the points that wasn't included in here is my biggest concern would have been the properties directly to the north of this building. And the fact that they put an alley between this building and the other properties, I
To
think.
clarify, that was.
That was
There are.
Yeah, well, it was there, but
Yeah.
again, we're not putting a building right up next adjacent, 3 feet from somebody else's property. There's ample space between this, you know, the new commercial development that went in and then the residential properties that are to the north. So I think it's a good fit, and I don't think the building is gonna depreciate any of the properties directly north of this building.
Okay. Get to that, I mean, just some background, there was some other boards that this went before, there may have been some disagreements with people, parties that were doing it, but when it came before us, our purview was to look at the design review board regardless of what those issues were, and that's, I believe, what we all did. Daryl, you got anything to add?
I would have to say we spent a lot of time on this building to make it look as good as it looks in the final thing. And from my viewpoint, it's a far more of a raiser of values compared to the suntan spot that was there before. And,
Of the previous,
yeah,
the
yeah,
building.
yes. And, I feel that it fits in quite nicely.
Okay.
Typical Shorewood.
So I guess, Nick, to conclude this, Nathan, I'm looking for, I guess I don't know what I'm looking for. Am I looking for an approval of the project or an approval of the discussion of
Sure.
some
Yeah, I mean,
substantive differentiation, or what am I looking for a motion for?
I think, based upon the way I read the court's decision, is that I think you could just move to close the reopened hearing. I'll,
Oh, because we
I'll
just
hear-
discussed more in depthly as
right,
to
right.
what the topic was.
You know,
Okay,
I was not, you know, maybe Joe, either one of the Joes has a different opinion. I was not part and parcel of the litigation in circuit court, but that's my opinion, would satisfy the
I guess that's open.
mandate of the court.
Yeah, my take on it is that this body can entertain a motion to reopen, reconsider the vote from March 22 of 2024. It could entertain a motion to close the record. And one of those two things will either be seconded and voted on, or you know, I think you basically have to say, after this discussion, should there be a motion to reopen and re-vote? And if that motion isn't suggested or seconded, then the motion would be to close the record and vote on that.
Okay.
Can I ask a question? What,
Yep.
what is the ideal outcome from the opposing the applicant? I mean, like, once if it comes back to us, I mean, I don't foresee us ever changing our opinion again.
That-
So is there
That may be the consideration of the court. If, I
Okay.
mean, my assumption is, and Mr. Sikata can speak to this, my assumption is if the board votes to close the record, we will return it to the BOA, and the BOA will do its thing. And if the BOA has commentary or instruction to the DRB, or if the court has commentary or instruction to the DRB, we'll act accordingly. But the idea at this juncture is the court couldn't tell from the record what the rationale on substantial depreciation is. My legal opinion is we've accomplished that. I assume that the project opponent disagrees, but it'll be sent back to the BOA. The BOA will do what it does, and if need be, it'll be sent up to the court.
I have a question. So if we want to acknowledge that we did take all those things into consideration, what do we have to do? One, does that close it or put it up for a vote?
I think he gave us that
Oh, he did?
opportunity, yeah, choose.
I know, I want to know if I'm choosing what I mean.
Oh,
That's what I'm saying.
okay.
Is
Well,
it-
let's circle back to that in a
Okay.
minute.
Right, yeah, if the board is satisfied that it has met the court's instructions to create a record of its rationale, so to speak.
Okay.
It can then.
Yeah, choose one of those. Go ahead.
Thanks for letting me just contribute. Thank you, by the way, for listening. I know these things can get a little tense, and I apologize if I got a little bit excited.
Joe and I actually like each other.
Well, I know. Thank you very much for letting me go on about things. Here's how I think. I actually think it's a very simple thing. My view, as I stated, is you guys have to make a new determination. And if you make the determination and you find that you don't believe it will substantially depreciate, then the applicant is basically happy because everything's fine for them. We might then say, do we want to reappeal and pursue this further? There's really no authority that I found for this idea that the judge is overseeing all this and we have to send it back to him to sort of sanctify everything. That doesn't make much sense to me in my experience. I think it could end right here if you guys decide it doesn't substantially depreciate. Then it's, to me, we want to challenge that again. For some reason, the attorneys are saying we should just have a discussion and then let the judge kind of bless it. I don't see it as being even appropriate, much less necessary. So it sounds as if from the commentary, you guys would find against our position. And I think it's actually, just as an attorney, the appropriate thing to make a decision, not just kind of have a discussion. I hope that.
So if I could restate what you said,
Sure.
maybe you'd like to see a motion to say that this is does not substantially
I
depreciate.
wouldn't like that, but I think that's what would be, if I was advising you as your attorney, I would say that would be the appropriate course.
Okay, so it sounds like we have multiple options to make motions of. I guess before we get into that again, I guess I'd like to ask one more thing, just to circle back to the discussion the gentleman's had earlier was, is there any other information that this board needs that they feel would help find the answer to this question that's being brought before us? Would it be the meeting minutes? Would it be additional expert testimony or something, the affidavit that the gentleman has that you alluded to that we have not seen? Anything like that, anything at all that people would need more information to make a informed decision today based on what you've seen or need to see or think you need to see.
I got the good feel about how the discussion went. The discussion we had tonight, I think, was what we needed to do.
And you think the material here, okay,
Yeah, I've been up here and with everybody else's input and discussion, I'm comfortable.
and I think that's good because you weren't part of the first.
Well, yeah, that's why I asked the question.
Yeah, well, I want to make sure you're
Yeah,
informed.
I'm
I
good.
really don't want to be here again if possible.
No, I'm good.
Anybody else have anything on that regard? Did you have more follow-up questions, Mary?
I'll let somebody make the first motion because I'm still confused.
Yeah. Right. Would anybody care to make a motion in regards to this topic?
I'll make a motion. I'd like to make a motion that we close the discussion on this issue so that our meeting minutes can reflect the input of no adverse depreciation.
Okay, we have a motion to close and come to a conclusion that there's been no adverse depreciation in regards to this project. Is there a second?
Sorry, wait, real quick. Are we forecasting depreciation or saying that there has been?
No,
No.
you are essentially putting yourself back
Yeah,
to March
so-
22,
so it would be
2024.
There will not be.
There will not be, I suppose.
I
The
guess.
language would be will not.
We don't anticipate any.
So I guess with that amendment.
Well, I have one more question
Yeah.
after
sorry.
that. If we close it, will these minutes get read into the record?
Yeah,
Okay,
parts, well, this is a recording, right? So I think
right,
that-
but I mean, it will become part of our record, so we don't need to open.
Oh, I believe so, yeah. I mean,
Oh.
normally you do minutes for meetings, but this may be a special exception because we're recording. Is that?
I would think if it goes forward, it will probably transcribe this.
Yeah, I think it'll be transcribed. Yeah.
Yeah, it's the record.
So that will become the meeting minutes?
Yeah, this is the record. So. it's got a recording.
Okay. Any more questions? So we have a motion.
I'll
Can I just
second.
read-
Mark,
can I
could
just
you
take
read
the
it back? Yeah,
My
so we all know what
understanding
it
is the
is.
motion is to close discussion to allow the meeting minutes to reflect that the design review board, as in we, does not anticipate adverse depreciation.
Is that accurate? Okay.
Yeah, I think that you said that the board had given it more than one consideration in determining that factor. That it was discussed, all the factors were discussed and determined that.
Okay, I don't, is that part of the motion or is
That's
that,
a different.
Nah.
that's different?
That's.
So could you read the motion one more time?
Close discussion to allow the meeting minutes to reflect that we, as the design review board, do not anticipate adverse depreciation.
I'll second that.
I thought I heard the word substantial when it was first
Yeah, it should probably have the word substantial.
Do you want to say substantial or
Let's,
adverse?
why don't you read what you have and then you can confirm if that's the
Okay.
motion you're making.
I have closed discussion to allow the meeting minutes to reflect that we, as the design review board, do not anticipate adverse depreciation.
Well, no, I don't want, let's take the word, adverse, we wanted to the minutes to reflect the discussion on potential. How do they phrase it in that?
Substantial
Substantial
appreciation.
appreciation.
Substantial depreciation. Let's get with the same language.
Both discussion to allow meeting minutes to reflect, we as a design reviewer do not anticipate substantial depreciation.
I would add of this building and neighboring buildings.
Of this building and neighboring buildings.
That's the motion.
Okay. Could we get a final reading of that, please? So
Close
everyone's
discussion
clear.
to allow meeting minutes to reflect that we as a design review board do not anticipate substantial depreciation of this building and neighboring buildings.
And Daryl, do you second that motion?
I'll second that.
Okay, we are getting there. Is there any more questions or discussion regarding this? All in favor, say aye. Aye.
Aye.
Are there anyone opposed? Motion carries. Thank you for your time, gentlemen.
Thank you again, everybody. You guys have more or we have?
Yeah, you
have
guys,
one more.
we have another
Thank you very much.
patiently waiting.
You want to talk to your mic? Where's the lawyer? I know you really don't.
Oh, that's.
Maybe it's easier if I'm on this end.
Yeah,
Yeah.
typically the applicant sits up here, yeah.
Oh, all right.
You signed it.
Yes.
No, there's some. Right.
You don't have to, apologize for the length of the first item, because I'm an attorney. It's just absolutely fascinating.
You might want to share if you want to set the screen, just for the,
Oh.
we typically do share the screen out.
Okay. Everyone can see me, I'll just turn it on, yeah.
Are we still recording? Is Nathan still?
We are still recording, I'm
Okay.
gonna record the entire meeting.
Perfect. Let's go. So I am reading. Number 4, consideration by special exception of the application and plans on file for the location of a previously approved late sign commercial property 45 North Oakland Avenue. Presume you're here for that.
Yes.
Excellent.
So I did provide a cover memo of the history of this. This also did go to Board of Appeals and is going to send back to you.
Okay.
More specifically or more shortly, and if you want to chime in as well. The board approved this with a minimum clearance of 7 feet, but did not approve it by special exception to do that. So when you approved it, they installed it in one location. The building inspector said that's not where they approved it. Then they moved it to a different location, still not where they approved it. But the bigger challenge with the second location was that it was the 7 feet. They argued that they were allowed to do so. They applied for a variance with the Board of Appeals. The Board of Appeals said, actually, what you need is a special exception from the design review board. So my understanding is that they have now applied for that special exception to keep the sign installed where it has been installed, with the special exception of not meeting the 8-foot minimum clearance standards. This is a photo of where it's currently installed. They've installed a planter below it to preclude anyone from being able to, run into it or damage or anything of that nature. This is all on private property. That's not a public sidewalk. That is the patio space for the private development. So that is my understanding, is that they are seeking a special exception to allow the installation in this location with the condition that it does not have to meet the 8-foot minimum clearance. Am I accurate on you?
Yes,
Yes,
and I think maybe just a little context would. Yeah, I think maybe just a short chronology will also help, because this has been a little bit confused from the start. I'm the owner of the building, so I'm here on behalf of Stonehouse Collective, which is the really nice tenant I have on the first floor there. The original approval that was received was followed, and the sign was in a different location. The sign was was a blade sign at the patio. And the, when installed, and it was actually installed there. Shortly thereafter, Stonehouse wanted to change the lighting, at its
Those big
location.
light fixtures.
Yeah,
As I recall.
yeah, and they're nice. At night, they're very attractive. Our light fixtures were, let's say, not as attractive, and were installed back in 2010 when the building was constructed. With the new lights, the location at the patio just didn't work. it was too close to, the lights cast differently than our lights. You couldn't really see the sign, and the sign was moved. This is the part that's now shown in your photographs. The sign was moved to a pilaster that doesn't have a light on it, and it's on the front of the building. Following the previous approval, they felt, I wasn't involved in all of this. I guess I'm the guy who gets to maybe hope to get it cleaned up. They moved the sign from the patio, which is completely private property, and ours, it did extend in the same fashion to this location on the front of the building. And the previous approval had allowed for 7 feet. I think it's cited in your materials. So they just did it, you know, at the new location that way.
I
And
leave it the photo of where it was installed initially, if you're interested. I just,
yeah, I think there was one in the previous
in the
record.
Board of Appeals, it was in there, but since they're not seeking approval of that location, I didn't include it, but that may have been.
Oh, I think,
So this is where it was
Yeah.
actually approved,
yeah,
or installed, I should say.
yeah. So you can
With
see
old
the,
light fixtures, et cetera.
our somewhat smaller plastic light fixtures. What I actually did then, I mean, I was really, they're very good at what they do, in my opinion. And they chose a light that I thought really helped the overall appearance of the building. So I then, at my expense, not at theirs, replicated the light in another 6 or 7 locations on the building, so it would be consistent. If the rest of the building had those lights with Stonehouse having those new lights, I think it would have looked not great. Let's say it that way.
I agree. How high was that one?
So that one,
That doesn't look like 7 feet.
Well, that's more than 7 feet up.
Yeah.
right, that one, I think one way to gauge that distance is we've got a
The windows.
14.6 interior premise height there. So that runs, you know, above that sign band.
So how come you were getting
Yeah, I guess I'm not
approval
sure why
on
we
7
would-
feet?
Yeah, we would
it's
have
higher
7
than the
feet, it's
windows,
that
which-
high, but
The original approval had allowed for 7 feet up to a maximum of, what was it?
Says up to that band, I
up
think.
to
Yeah.
18 inches in height.
Yeah. Yeah, up to that lintel, maybe.
Yeah, up to the level.
But, you know, and again, I wish I would have been consulted, when the move was made, if we would have talked to Justin about it, he would probably have said, no, it was approved for that location. It just, with, the way the lights, the new lights were casting light, these design experts felt it was better at that location and better at the previously approved height, even though that wasn't the height they put it at. So there's kind of a chronology, and I think unfortunately, one of the things that came in kind of late to the game is they asked me, you know, if I would approve the new lights, which they then came through to get approval from Shorewood for. And I said, well, when you do that, let's do it for the whole building. So that was the context I wanted to provide.
Okay. I vaguely remember some discussion about the awning. I think we made that higher between the lintel and.
The awning was projected to go over
Yeah.
this lintel, so
Maybe there was a.
they
confusion.
installed the wall sign of the awning as approved. So there is no need for further discussion on that. That is
Yeah.
what you approved.
Okay.
They installed this initial sign, blade sign, higher than what was approved. So Justin said that's not where it needs to go. It needs to be relocated. Then they relocated it in a place that was not approved.
I get.
And Justin said, no, you need to put it back. And they said, no, we want to keep it here. Then the whole process of Board of Appeals, and now they're coming here for a special exception to install it in the location that they like.
I'm following, you know.
What
Which
is our
which is
rules
this.
on signs in the front of the building?
Well, it needs to be approved by special exception.
They're allowed to have one wall sign and one blade sign. So the type and quantity is there.
Yeah.
So in my memo, I do believe I say the only thing that is not compliant is the blade sign shall have a minimum placement above the sidewalk of 8 feet. All of the requirements of the village's blade sign regulations, including quantity, size, hardware, have been met. So the only thing that's left is the discussion of whether or not that is acceptable to be lower than the code typically allows. And in order to have that approval, it needs to be approved by special exception.
And I think also at that location, though, right? Because the first approval was.
It would be implicit that, yeah,
It would be approved there.
Oh, I got you. Okay. Yeah, I just wanted to make sure you're.
appreciate it, yeah.
Having listened to the previous item, I wanted to make sure you're right. Yeah.
Is there a reason that they want it at 7 feet?
Yeah, I think because of the way the lights now work, I think it's easier to be seen there. And I think,
Those are big lights.
yeah,
Yeah,
Would,
they were expensive. I mean, I can attest to that. But you know, the other thing that's happened here, and I think maybe this is just a little bit of context about the decision you're gonna make tonight too is. I mean, this has been back and forth, and obviously there were a couple of mistakes made. This is a, you know, new business, hopefully a soon to be very successful business. It was a very expensive build out. She basically said to me, the owner of Stonehouse is a woman named Anna Franklin. She said, you know, I don't even want to put another application in on this. I'll just take the thing down. You know, and I said, like the gentleman said earlier today, take a breath. Let me just step in. I'm happy to go to the meetings. Doesn't matter how long they are. I'm happy to kind of put forth, yeah. I'm really glad there's not another attorney here that's gonna be countering what I'm saying, but, you know.
Nathan's still listening in, so be
I
careful.
think,
yeah.
I guess I saw our building, so, you know, I think one of the things that, kind of applies here is just, you know, this is a great village for supporting small business. That's why I built there. I was sitting there, I was kind of, interested to say that one gentleman really thought that the Cornerstone really, you know, did a lot for the corridor, and it's a good model. This is a small business owner who's just kind of like really trying to get through her first year, and to move it again, incurs expense. I would probably be the guy who did it because I feel sorry for her. But I just think this is a good location. We made the record reflect that, okay, it's at 7 feet. That's because of the original approval was at 7 feet. It's not going to be grabbed by somebody. It's well off the sidewalk because we did set back this building. We set back the building to create patio space. So we put a planter there. They'll actually agree to always have something there so that, you know, some kid with really good hops won't yank it down or, you know, whatever. But I think this is a real nice location. They're design experts, and that's where they relocated it. I'd really like to be able to say that Village appreciates their investment in the community, my investment in the community, and that, you know, there hasn't been a single complaint about it. And I think, quite frankly, I've looked at it a lot, and I think it looks really attractive at night. You see it better at that height. So that's kind of what I'd like the record to reflect.
Thank you. So yeah, with that, I mean, I guess my opinions on it, I think it's appropriate place. I think it's fine. The scale of the actual size of the sign is not that offensive. I still have a little trouble believing we would call out a 7-foot height, but I don't think that matters for this discussion because we have before us what they are asking us to do, and that is what would be the special exception. So that's neither here nor there what the previous record was, in my opinion, but while you all discuss, I might recommend that, you know, the type of sign is appropriate. The location seems appropriate, particularly given the fact that they have such large elements on either side of it. I don't know that I'd want to see it much higher, but I'd open up that to the rest of the comments and look forward to a motion.
Can I ask a quick question? What is this picture that we're looking at here? Is that where it was installed? It looks like it's.
Oh, that's the one?
Yeah.
Yeah.
That,
This is the original application.
That- yeah,
shows
that
where
was the
they-
original.
Before the new lights are in.
Where they
So-
proposed it.
Yeah.
that's
The
probably
original
why,
proposal was for that location.
because that doesn't look like 7 feet.
Yes,
Agreed.
it is that.
I would say that again, that doesn't necessarily matter if it is. Let's
Right, I just
review what we
wonder,
have.
I know, I wonder if that's what we were
Awesome.
thinking, like that looks appropriate.
Yeah.
I would have to believe you that the lighting affects it at this height, because I think it looks too low.
Yeah,
Yeah,
I think it looks like a mistake.
it does.
Like, I don't like they went to 7 feet. If I was going in there, I'd put it so that it was right at the same height as the transom,
Yeah.
bottom of the transom, which is where the new big lights, their transition to their cap is at the transom height. And
Oh, I see, yeah.
I wouldn't want like moving it to cause that. Like, I can see the planter, I don't think people would really disturb it. Aesthetically, I just think it looks low. Like when you hang a picture at home and you're like, it's okay. And then you look at it and you're like, it's not okay. I have to do the work.
Sound like a couple of you agree with that. So
I-
I've got a question though
with that
on
too.
your height though. So when you say 7 feet, is that to here? Is that to the bottom? Or, I'm sorry, you didn't say 7 feet. You said the
No.
transom.
Handsome.
Where is that transom falling on this
I would-
sign?
I would say that if I were gonna do this, I would center the bracket that attaches to the brick on the center line of the transom, the bottom line of the transom.
Because I think that's important for later.
So assuming bricks are 3 inches, there's 4 bricks above that to the level of the transom.
Okay.
So that would be a foot basically.
That, I mean,
You could,
Can
Well,
I make a counter argument?
Sure.
Because I think it's competent, right?
We're not doing lawyering stuff.
No, we're not.
Yeah, I was gonna
No,
say,
no disrespect.
you know, I think beauty is sometimes in the eye of the beholder.
Sure.
It doesn't strike me that way. I'm looking at it in a much broader context too, in terms of how we want to support business and how we don't want to, you know, drag something like this on any further. I'd like to ask for an approval with the thought that, you know, if something different is approved tonight, that does just incur more cost. I don't think there's been, where I might hang a painting might be different than where you might hang a painting. You know, I just think there's a broader context here, trying to support small business. And I think, given the purview of what the design review board, you know, can take into account, I think we heard a lot about that earlier today. I think this one particular business owner who's, you know, fed up is the wrong word, but frustrated, sending me to do this on her behalf. I think that should also go into your consideration for your decision today.
I agree. I consider it. There's a lot of times people come in with a lot of things that are going on in the broader context. But I look at this aesthetically as a design piece, and it's a slippery slope when we start saying, well, I need your backstory to understand why we can have an exception. To me, aesthetically, it's not in the right place.
Well, the prior approval did not require that aesthetic. The
We're
prior-
throwing that out
when you
there.
put it in, it
We're
was-
approving what's before
Yeah,
us.
that's it.
You know, we're not referring to a free.
And-
So, you know, in the course of several months now, the body has, we don't have the body's decision yet. But, you know, that wasn't an objection that was raised then, and steps were taken. You know, the 7 feet was the 7 feet, and steps were taken following that.
Right, I believe the steps that were taken was for that to be continued installed there. This board has to affirm that special exception.
Yeah, okay. Well, I guess I've said my piece. I mean, I think this has got certainly a broader context for me. In
For
terms
sure.
of how I feel about the
I
building.
fully understand that. I guess where I'm coming from it, you know, I kind of do agree with Ryan, but where I'm coming from at it in this regard is sort of taking that into account in the sense that this does not offend me. So while I agree, and you know, if all things were equal and somebody said, where do you want this mounted? I would put it exactly where Ryan is talking about. However, now that it's up in the place that it's there, and you know, it's not terrible. Plus, you got a planter in front of it, you got the lights. I think it's fine. It seems pedestrian scale. But that is why we have multi-member boards, because we
Right.
all get to weigh in. So
Yeah, I'm a little concerned about the precedence issue.
As I recall,
it's
you
special
were-
exception,
Okay.
so it's not
Well-
necessarily a precedent in my opinion.
Right.
They can always point to it.
Of course they can, but yes.
there's gonna be a lot of differences between this building and any other building that you cite in Shorewood, because we have a setback there that, you know, unlike the building you were previously discussing, we didn't go to the sidewalk. We didn't mass the 4 stories. We stepped back our 4th story. So those all have economic impact in terms of an owner later on. 24 units in a parcel that was quite a lot larger than this parcel you were just discussing with much higher units. So I guess I'm also here as a Shorewood taxpayer and saying, what's the right thing to do? I've said my piece.
Understood. Any other comments?
I was wondering if I could just direct everybody to the applicable standard. It's 445 in the design review in the sign code area. The 445.23 special exception gives you a pretty broad discretion on this kind of thing. It talks about that the appearance, nature, and type of the signage is not so at variance with the appearance and character of other signing in the area. So what you were talking about being unique, you know, obviously you can consider that. So I just wanted to reference you to the ordinance that has the standard. The other question I had, because I remembered this coming up at the Board of Appeals, and because I was with that body when this was there, is how much lower is it than what's, I thought it was like 1.5 inches, but maybe I've got that wrong. Isn't it just,
13 inches or so.
oh, okay. Maybe I misremembering. So I thought it was close, but maybe it's okay. At any rate, it's 445.23.
Yeah, we have it in front of us, Nathan.
Yeah,
Oh, okay.
So yeah, any motion that would be made, I would ask that you provide at least some, you know, one or more of those exceptions that are specifically allowed in that ordinance that's on the 2nd page. Anyone care to make a motion?
We'll make a motion that, to approve the sign as is.
So approved by special exception. If I could help you out.
I'll make a motion that we provide a special exception to allow the sign as is marked.
Are there any of the bulleted points that you might like to reference of why that might be allowed by special exception? Yeah, I'm on the second page.
Oh, I got it. 7 says, size of proposed sign in relation to the area. Basically, the building. We use special exception based on number 7 and number 8. The building.
Can you tell me what that is? I don't know what it is. Oh, sorry. It
Effect
is.
that proposed signing will have on the appearance and character of the applicant's property adjacent to neighboring property.
7 and 8.
7 and 8. Okay. Can you read it back to us? I mean, does everybody have 7 and 8 in front of them?
Yes.
Read it back to us.
I don't have 7 and 8 in front of me.
Sorry, so just read 7 and 8. You just read 7 and 8.
you're 7 and 8.
Say 7 and 8.
Approved by special exception to sign as is.
For 7 and 8.
Based on condition 7 and 8 in the village code.
Does that sound accurate? Excellent. Anybody care to second that?
Okay, well, here we are.
It's not getting a lot of love. Anyone care to make a different motion? Yes, sir.
I thought your earlier statement was that you thought it was in a location that was acceptable.
I did.
And your opinion is that.
Not prepared to second it at this point.
I see. Okay, well, that's really unfortunate. You know, well, you have to take the action that you.
Would it be a motion to resubmit?
Could be.
Yeah, I make a motion to resubmit the sign raised above 8 feet per the code and in alignment with the bottom mullion of the transom window, center bracket, attached to the brick. Its center line centered on the bottom line of the transom window.
Would it really be a motion to resubmit or just a motion of approval as?
Or approve if.
We don't need to resubmit anything, right? I mean, if he approves it.
I guess I would ask Attorney Bayer, so the sign has approval for a location where it's not installed. They've applied for a special exception to install it where they would like to. There seems to be no desire to second that motion. I don't know that it's relevant to
Approve something.
approve something that wasn't applied for. The record could state that you would be willing to approve it in that location, but to me, the motion would be to deny the special exception. Am I
Sure.
wrong, or what are the options?
Yeah, unless, because remember, you can always grant a special exemption, special exception request with conditions, right? So you could say, well, we're gonna grant a special exception to put it in this area, but conditioned on the height being X. Because would it require a special exception to go there anyway, or
No,
no, it wouldn't?
the
Okay,
special exception is only to keep it in a location lower than the code allows.
then it would just be to deny the special exception, I guess. Would either grant or deny the special exception. Because they wouldn't,
Option would be to
that-
remove the sign or install the location or to resubmit.
yeah, because
That's correct.
if they wanted to put it there at least 8 feet, they wouldn't, would they get a permit for that?
They would need to get approval because they don't have, their previous approval was for installation in a different location.
Okay. But there'd be no, like, if it was a minimum of 8 feet, would that meet the code?
Yes, they would not need a special exception to reapply to get it installed in a different location if it
Yeah.
was 8 feet.
So I was just trying to think of a way to be creative, but yeah, I think it's just probably grant or deny.
I don't know if it's appropriate for me to talk during the
Go ahead.
course of your deliberation. That would be an unfortunate decision. I appreciate your motion. What will happen now, understanding the mistake that had been made at the village, approving a 7 when the code
They
said
didn't
8.
install it where the village approved it.
I'm just saying,
They chose to install it in the
there's,
location.
we can certainly point fingers back and forth, but
Well, you just did.
yeah. And
I would argue if it was 7 feet on the corner, that might be a different story, but
Sure.
you have 7 feet at a different location.
We did not install it the way it was.
We don't really need to argue that. What I'm going to say is,
Permit's not for this sign.
yes, and here's the result. You have a really nice sign that has been displayed without people taking pot shots at it. In fact, I'm sure they've had some compliments. Different people will hang pictures at different heights. I've complimented, so I can say that that's been the case. This sign will come down. We're not going to reapply because, at a point in time, her frustration has now become my frustration in terms of the expense here. We've been before the board twice. We went to I think that was a wrong step as an attorney, but Board of Appeals. It's dragged on too long. I'll say that unfortunately, a lot of the things that we do for Shorewood didn't sway this body. And I'll certainly, when I'm talking to her, I'm just gonna say that's the way it goes. It does affect, my view of the village. And I think, I was here on one other occasion. For this various tenant, there's the same tenant on a different issue, where we were installing 2 windows that were needed to get some light to the back of the. I'll not make this long because it's a different situation, and there was quite a bit of discussion. Well, there aren't any other windows on that side of the building, and we kind of had to force through an approval there. Stop by the store, take a look at what those windows look like that were approved. Look at the expense that I incurred to do that, and the window treatments that they now put there, and how they got a beautiful conference room with light. I view this as kind of the same thing. It shouldn't be that hard. It really shouldn't. And as an owner, I've made my investment there. It doesn't make me really that incentive to do anything else there. It's just, I thought this was a pretty easy ask. I thought initially the board kind of, or whatever, this isn't a board, right? Or, yeah, this board understood the reasoning behind it. I thought that made a big difference in terms of what's gonna be the result here. There won't be a sign in that building. It's too bad. Because I'm gonna kind of draw a line at my frustration now and, you know, to move it up to that, 13-inch location and the cost of it and then repairing the brick and everything else, I'm just kind of done too. But I appreciate your time. And we'll live with whatever the decision is. I thought it was a much easier ask. Not creating a precedent and respecting both her investment and my investment and, yes, it's been 14 years of paying Shorewood taxes. These two buildings are probably the highest taxpayer in your village.
Thank you. Yeah, I know the building has been cited as a number of times as a jewel of Shorewood, so it's been, I think even on the code, when we were rewriting this, the commercial code, it was cited as, something we should desire to have some things like, so.
And
With
when it
that,
comes down to a sign like this and it's like, okay, well, thanks.
again, I guess I would say that doesn't mean that we kowtow to everything that you ask for either. So we are a board of 9 people, there are 7 here.
Right,
today,
and I
so
think for a big
we have to
ask
come
like
to
this,
concession and as a board, and so that's what we're
Yeah.
trying to do.
I think this is a small ask, I really do.
I agree. Any other motions?
So then the motion to deny the special exception.
I'll second it.
All in favor, say aye.
I-
Anyone?
Can I have hands for that?
All right. Who's, yes, show hands.
1, 2, 3, 4, 5.
And nays?
I'm Chris.
Motion is denied. Thank you for your time.
Yep, thank you.
Sort of.
I understand.
Appreciate the motion.
5 is future agenda items. Anything else?
Nothing.
And anyone care to adjourn?
Move we adjourn.
Second. All in favor, say aye.
Aye.
We are adjourned. Thank you.